Well, I think we'll get started now. I'm Peter Keisler, and it's my privilege to host the final panel of the evening, which is on the presidency and the law. And these panelists are uniquely well-positioned. If everyone could get a seat. I was just saying that these panelists are uniquely well-positioned to address the subject. Each of them, in addition to all of their other distinctions, served at the outset of a new administration as White House counsel, meaning it was their job on a daily basis to provide a new president not only with legal advice, although of course that, but also with their broader judgment on some of the most challenging issues facing a president, and to do so not simply as representing an individual president, but doing something even bigger, which is representing the office of the presidency itself. And so their portfolios required them to play leadership roles in matters ranging from national security to separation of powers to judicial selection to government ethics to presidential appointments and lots of other things. It would use up all the time we have if I actually tried to fully describe their rich and varied careers. So I'm going to necessarily be brief and incomplete in introductions, but just to give you a sense of who we're hearing from, Don McGahn, to my immediate left, served as White House counsel under President Donald Trump from 2017 to 2018. Senator Mitch McConnell, who was then the majority leader, described him as one of the most successful and consequential aides to any president in recent history. In addition, he had previously served as chair of the Federal Election Commission, as general counsel to the 2016 Trump presidential campaign, and as counsel to the House Committee on Administration and the National Republican Congressional Committee. He is today practicing at Jones Day, where he leads their government regulation practice. Next to him is Alberto Gonzales, who served as White House counsel under President George W. Bush from 2001 to 2005. He has also served as a justice on the Texas Supreme Court, as Texas Secretary of State, and as the 80th Attorney General of the United States, and I had the privilege of serving under him when he was in that capacity. He is now the Dean and the Doyle Rogers Distinguished Professor of Law at Belmont University College of Law, where he writes and teaches about presidential power and national security and constitutional law and many other relevant things. And Bob Bauer served as White House counsel under President Obama from 2009 to 2011. He also served at different times as personal attorney to President Obama and to President Biden. He was general counsel both of the Obama 2008 presidential campaign and to the Democratic National Committee. More recently, he has been involved in leading bipartisan, privately organized task forces that have focused on recommendations for reforming the Electoral Count Act and the Insurrection Act. He's also written a series of exceptionally thoughtful books and articles on matters relating to governance, including a book with Jack Goldsmith on reconstructing the presidency. I'm going to leave out actually the full title of that book because it was After Trump, Reconstructing the Presidency, and that may not have been the most far-sighted title to give the book at the time. And most recently, he has come out with The Unraveling: Reflections on Politics Without Ethics and Democracy in Crisis. So thank you all for being here. And let me start with the obvious question. We've just finished a presidential campaign in which one candidate said that the other presented a profound and grave risk to values of democracy and the rule of law. That other candidate, of course, contested the charge and went on to win and is now preparing to reassume the presidency. So, and maybe we can start, Bob, with you and move down the line. What are your expectations for rule of law issues in the new administration? What do you think we should be watching for and looking at, both in the very near term right now and as we go deeper into the term?
Well, thank you, first of all, for inviting me. I'm really grateful to be on the same panel with Don and the General. And we had a nice talk outside about our experiences as White House counsels. that's a question that could be broken out into several parts, so I will very briefly just pick out one part. And that is, the President-elect Trump has expressed or articulated in the past a very robust view of Article II power, and also a very direct, aggressive path that he would like to travel to the achievement of his policy goals. And that has included recently, for example, the tweet that he issued in which he called for the Senate to follow him down the path potentially of a government by recess appointment. He didn't say if necessary. I think there are members of Congress the members of the Senate who have said if necessary. And so you can imagine that this presents, really, really significant issues. What does that precisely mean? Obviously, there's a difference between Donald Trump's more, performative, his performance as a candidate, his performance as president, and what in fact he winds up deciding to do. But that certainly lays a background here of potential significant rule of law issues that his recently named White House counsel is going to be instrumental in addressing. I should add, and then that's my last comment, particularly in a context in which President-elect Trump in the past as president, seems to have expressed some perplexity about the appropriate relationship that the president should establish with the Department of Justice. And he thought the relationship ought to be one in which he had more control, if you will. And there has been, although it's been contested, a view of the department having to have a certain measure of quote-unquote independence. So all of this, it seems to me, as a package, presents some significant potential rule of law conflicts and issues.
Having worked at the Department of Justice and also at the White House, the relationship between the counsel and the leadership at the department is extremely important. And they each have to know their boundaries. I think it's very important that the Department of Justice have the liberty, the flexibility to make law enforcement decisions without political influence by the White House. When I was White House counsel dealing with John Ashcroft as the Attorney General, and I know this has continued as a matter of practice, there was a limitation on the number of the people that could talk to the Department of Justice personnel and on what subjects they could talk to them about. And generally, it would involve me having a conversation with Larry Thompson, the Deputy Attorney General, or with John Ashcroft. But those conversations would be very, very limited because it was important for President Bush that the White House not be placing any influence on investigations or prosecutions at the Department of Justice. So there was a clear separation there. And obviously, it's very, very important for the Attorney General to set an example for everyone within the Department of Justice about that clear delineation of power and authority. And part of my concern is the fact that there may be a desire by the incoming administration to sort of limit the authority of the Department of Justice to make decisions that it has made historically with respect to investigations and prosecutions. And it's one that I think it is dangerous, and I think one that we need to watch very, very carefully.
The question was about kind of what the front of mind rule of law issues are, and we've gotten to sort of White House counsel, DOJ. So I'll continue that theme because it's going to be more of a discussion. So I don't think we're going to be limited to yeah, I think it is. Maybe there it is. Okay, yep, that would explain it. What I said was the question was really more what kind of rule of law issues are going to emerge, and we've already kind of right into DOJ and the White House. The interesting thing that's coming up, I think, is different than what happened in 2016. Trump ran this time very loud, proud, notorious, open, and very clear that he thought the Department of Justice and the FBI needed significant changing and reform. So there's a lot of that baked into the cake, so to speak, particularly given his victory, which was pretty strong and pretty decisive. So Elections have consequences. The people have spoken, despite the other side claiming threat to rule of law and threat to democracy and all this other stuff. So if you're the incoming president, you think you were very clear at what you were going to do, and you won. Now, that doesn't really get into the weeds. Certainly, people trying to launch prosecutions because of some sort of subjective political reason is not really going to work. Any defense lawyer gets wind of that, they're going to move to quash the indictment, you're going to lose the case. So there's a very practical reason why you don't want to do it. If you look at the history, though, of the contacts policies between DOJ and the White House counsel, they're relatively new. Griffin Bell did a speech or a memo, I don't remember what it was a memo, and it was really intended to ensure that random White House staff weren't calling random DOJ people, and that it was more of a containment policy as to who was going to contact who. And it made good sense to have the counsel to the president talk directly to the attorney general to ensure that there was a fixed line of communication. It evolved over time, and I think it was Attorney General Ashcroft who put out a memo in 2002 that really made more of a separation. Now, I'm assuming we all understand pre-Watergate and post-Watergate is a whole different relationship between the Department of Justice and the White House. Pre-Watergate, certainly much more contact, much more communication. You know, one president had his brother as Attorney General. You don't think they talked about things? Certainly they did. But Watergate changed everything. I think the contact policies, I found them, and I issued a memo very similar. I think it was identical to the memo I inherited. I don't think it was changed under President Obama. I think it was probably McCasey issued the kind of last one at the tail end. And I saw it as a way to ensure that folks were not, you know, randomly calling about their aunt has a speeding ticket, so they're going to call DOJ and make a mess. It can go too far because there is a number of things that the president, his White House staff, the Attorney General, and the Department of Justice really have to work with hand in glove. National security issues, alignment on litigation position before the Supreme Court. For a new administration, are you going to change positions? The list goes on and on of things in the world of what I call legal policy. Again, to end where I began, elections have consequences. So when a new president comes in, it ought not be surprising that things are going to change, positions are going to change, things may flip. There's a mountain of recent Supreme case law on administrative law. Loper Bright is sort of the shorthand for what is really administrative law revolution. So there's a lot of thought that needs to go into that, and that's the sort of thing that the president, as the head of the executive branch, his White House counsel, his White House staff, the Attorney General, the Solicitor General, that's the sort of thing that I think there needs to be more communication on, and not assume that DOJ can just figure it out. So I'm in the camp of this sort of overdone contact policy can lead to some silly results and to some misfires on policy in areas that really matter. So there's a little bit of difference, but maybe not.
Would you think the no contact policy could be?
Well, it's not a no contact policy. Every policy says the president's in charge and can contact the attorney general.
No, sure.
Right.
But in terms of channeling contacts, would you think it would be more appropriately limited to individual law enforcement decisions as opposed to broader policy? And would you see a role of separation for those kinds of cases?
I could see it, sure.
Look, I think that
But
with
a lot
respect,
of the prosecutions are brought by U.S. attorneys, and you know, there's countless prosecutions. And my point is, don't throw out the baby with the bathwater, because there's a whole litany of things that really the president should be heard. And in my experience, we had meeting after meeting where we'd say, okay, the president thinks we should do X, and DOJ career lawyers would say, well, the department's view is blah, blah, blah. And well, that's nice, but that's just not it. I mean, there's an executive order that says OLC is kind of the final word on points of law, and that's a legal analysis, and I think every president should welcome an objective, soup to nuts law review article on a point before making a policy decision. I don't think the policy should drive the legal analysis. But on the other hand, in my experience, so many questions are mixed questions of law and policy, where depending on how you shape the policy, the legal framework may or may not change. And I think if you get too hung up on this idea of this, as you've, and sometimes it's shorthanded as like no contact. It's not no contact, and you need to do that. Now, if you have White House counsel call and say, hey, I want you to go indict so-and-so, that's not really realistic, and that's not really the sort of thing that I hope would happen. And there's a system where you still have to bring it to a grand jury, and you still have to do a lot of things. It's not Thomas Jefferson running around in the Aaron Burr trial anymore, which apparently happened, and he was president. Burr was not, and that's the history. But I'm in the camp of we do have to rethink a lot of these policies that have been built up over the years, and the incoming president certainly campaigned on that.
Well, absolutely. And I think that, the Attorney General wears two hats. One, he or she is responsible for promoting the president's law enforcement policies. Two, the Attorney General is the chief investigator and prosecutor. Now, with respect to the first, yes, there is contact, because there is law enforcement policy that is going to require the participation of the Department of Justice in order to have the president achieve what he or she promised the American people. But it is with respect to investigations and prosecutions where I think you have to be very, very careful about contacts between the White House and the Department of Justice in terms of, as you say, you don't want people at the White House telling someone at the Department of Justice, please investigate this person, please prosecute this person.
Even in the prosecution context, though, I'm thinking of Gitmo versus a federal district court. There's a policy implication, even the prosecution side, that really goes to core presidential authority. So my point isn't to disagree. It's that shorthanding the idea of, well, we can't, there's no contact thing. It's much more subtle and much more sophisticated than sort of it's portrayed in the media.
I agree. We have no disagreement.
I wanted to briefly, Don and I have known each other a long time and worked together. Even when he was chairman of the Federal Election Commission, I was in private practice, and sometimes he ruled against my clients, sometimes in favor, but we had vigorous conversations.
When was that?
Yeah, exactly. Always on the law and the facts, I might add.
Of course.
But there's one thing that you said I just wanted to kind of flesh out a little bit, and we can get specific about the contacts policy too. The contacts policy is implicated in the comment I'm about to make. You said retribution, that is to say, the sort of threat that you were discussing, where potentially there's a political demand that the Department of Justice initiate an investigation. I think, Don, you suggested, well, it doesn't really work because a good defense lawyer can get the indictment thrown out. I think that understates the risk when you have political direction of that kind that could have a retributive or political element. We all know that the very process of investigation could be the end goal of any kind of political initiative through the Department of Justice against a political target. An investigation can last for a long time. An investigation can sap resources, destroy reputations. I'm reminded of, I think it was Ray Donovan, who was Labor Secretary of Reagan, who said at one point after enduring an investigation the Democrats had called for, where do I get my reputation back? So these are risks that even if in the end there's no dramatic legal consequence for the target of a political retribution attack, we just don't want to have a country in which that sort of thing happens. And I think the norms that typically governed relationships between the White House and the department, norms that are reflected, for example, in the contacts policy, which is 100% discretionary. An administration doesn't have to have one. An administration can rewrite the one from the prior administration, make it more generous, make it more restrictive. Norms are intended to actually prevent even the investigative launch, if you will, regardless of whether it ends up putting somebody in legal jeopardy in the long run. And I think you probably agree with that. Don?
Fair point. fair point. You're always well-spoken, Bob.
And Bob, let me just follow up on that with one question, which is, if someone's indicted, they go before a judge. Judges really are all pretty zealous about protecting the rights of defendants. If someone's investigated, just investigated, and goes through the process you described, and it's politically motivated, what remedy do they have? How do you fight against that if you believe yourself to be in that position? And if that is something that happens, what is the answer either for the person or for other people involved in terms of how to deal with that?
There are two lines of defense. I will say very often in any kind of relatively sophisticated political attack, let's put it that way, I'm going to call it retribution, or a case that is tinged with retributive intent, it is very difficult to get a court to buy into the argument that, oh, well, this is all political. If there's some substance to it, then you have to go to the second line of defense, which is a defense on the merits. A defense on the merits from motions practice all the way to other pressures on the department not to bring the case, and then eventually, if the case is brought, winning the case. But why an administration has chosen to pursue a particular case, the motives behind it are not easy to bring into play in a courthouse with a judge. Very hard to bring into play. Now, maybe that motivation was so thin that it is plain that there are no merits in the prosecution, then you defeat the case on the merits. But I'm a target because I'm a Democrat, or I'm a target because I'm a Republican. That's clearly what's going on here. By the way, I'll bring an example of where that has not been a successful defense. Hunter Biden's defense. He made it very clear, and his lawyers made it very clear, they thought the case that was brought against him was a case that would not have been brought against him if he had not been the son of the sitting president of the United States, and that didn't get him anywhere.
So let me turn then to another issue, which is where we've seen these last few years 2 federal cases plus a couple of state cases, criminal cases brought against the former president. One of those federal cases, the one in Florida, has been dismissed. The DC case, neither of them is going to trial. But they've had a big impact on the law, on the legal culture. They produced a Supreme Court decision on immunity. They produced a district court decision holding that the special counsel regulations were invalid. And you have, half the country feeling that these investigations were the result of improper politicization, and you have others of us who don't agree with that, and who worry about what the failures say about accountability. Going forward, how do any or all of you think the experiences we've had over the last few years with these cases are going to shape or change the conduct of the presidency, law enforcement, decision-making, or anything else going forward? What are the ripple effects of what we've just been through on this?
I think I'm going to pivot to this all night, but it was an issue front and center in the recent election. The idea of lawfare and the reaction to these cases. I think if you look at the data of why people voted the way they voted, it wasn't just the border, it wasn't just inflation. It was what felt like to a lot of voters the politicalization of prosecutions and the feeling that folks were kind of stretching to reach a conclusion. And what's going to come, I don't know, because I feel in a lot of areas of the law, we're at a crossroads, kind of like we were in the 1930s, maybe a little bit in the 1970s, where what's going to come out in the other end is going to be completely different than what we came in with, and law students are going to be reading case law that's going to be decided in our sort of era here, plus or minus 5 or 6 years, that are going to be potentially seminal cases that are going to reshape. And how the cases against the incoming president are going to factor into that broader mosaic, I don't have any good answers for it, but it's one of these things, we're living in the moment. I don't think we can answer it until we get down the road and take a look in the rearview mirror.
I'm worried. I think it's fair to say that I'm worried. A lot will depend on the Attorney General, quite frankly, and a lot depends on the council, and a lot will depend on the president. The department, there are a lot of folks that work at the department. Many of them are career individuals that aren't in don't make decisions based on politics. I'm hopeful the department will continue its current practice, despite who is the president, despite who is the attorney general. Maybe that's too much to hope for given today's environment, but there are still guardrails in place. We have the media, we have the inspector generals. We have other institutions, and so I'd like to think that that things will continue, but it's going to require, vigilance by all of us to watch what's going on at the department, and be hopeful. After the election, I remember waking up just sad and depressed, not understanding how could the American people put someone with such lack of character and morals into an office that I once held and I hold dear. And the more I thought about it, it's because the American people, the American voter, looks at this issue of who should be president through a different lens than I do. They worry about feeding their families. They worry about their housing. I suspect none of us here worry about feeding our families, worry about our housing. We just have a different lens in looking at things. And from my perspective, rule of law, protection of the rule of law, was the number one reason to vote for the President of the United States. Most American voters don't think about the election in that way. And after I thought about it, I thought, well, that made me feel better, quite frankly. Maybe it shouldn't have. Maybe it should have made me sadder. But that's the way that I look at the election, the results of the election, is that I share many of the same values as Republican voters. I just put different weight on those values. For me, the highest weight, the strongest weight should go to protection of the rule of law and our way of life.
A couple of the developments that you cited, I think, are going to require a lot of work and reflection on the part of this White House counsel and future White House counsel, one of them being the Supreme Court's decision on immunity. That certainly has to affect the work of the White House counsel. Not the only affected legal officer or legal official in the government, to be sure. It will certainly be reviewed closely by the Department of Justice and others. That's one that I think has at this point an unknowable effect on how legal advice is presented to the president. Because presidents, of course, when provided with advice on very sensitive issues, are advised on the consequences, for example, in terms of potential impeachment, and would be advised also in terms of potential consequences of legal liability. That's one. The second, special counsel regulations you mentioned, I think for a variety of reasons, we don't have to go into detail here, are a dead letter. I think they have failed of their intended purpose, that is. We had the experience with the independent counsel statute. That didn't work. It was replaced by the special counsel regulations. Those have clearly not functioned, even according to their own terms. Now, whether, by the way, this administration decides, which it can, to simply withdraw those rules or to amend them in some way, I don't know. But certainly in their current form, I think the experience of the last couple of years, to go to your question, Peter, is they're dead.
So we had talked before about the relationship between the White House and the Justice Department, and that's certainly an area where the president has a lot of authority that presidents have generally refrained from exercising. So to bring up a couple of other areas where presidents have a lot of authority that they have refrained from exercising. Bob, I mentioned in the introduction you had worked on Insurrection Act reform. And for those of you not deeply familiar with it, there's a general statutory prohibition against using the military for domestic law enforcement. There's a statute, the Insurrection Act, that creates an exception to that, and the two things to be said about the statute are the exception is meant to be exercised only in the most extreme circumstances, and the president decides whether those extreme circumstances are present. And certainly there's been reporting that after the death of George Floyd, when there was a lot of unrest in cities, then President Trump talked about the possibility of invoking the Insurrection Act. His acting defense secretary said that he proposed sending paratroopers into cities to shoot protesters in the legs. He was talked out of it, or at least counseled against it. He called his civilian and military advisors losers, but he didn't invoke it. I think I've got that history right. So you've been working on the issue, and I think on emergencies, authorities generally. What can you say about what you think needs to be done there, what risks there are there, and what the prospects are going forward?
Very briefly, and by the way, I just want to mention one other thing I left out in discussing special counsel regulations. I think the Supreme Court's decision on immunity has also spelled the end of the special counsel regulations as originally intended. On the question of emergencies, there are reform proposals that have attracted bipartisan support. Reform of the National Emergencies Act has the support of Democrats and Republicans, ranging from Dick Blumenthal in the Senate to Chip Roy and Rand Paul. However, it is unclear at this point what can happen in this lame duck session. It is unclear whether that reform is going to wind up being on ice for a while. It depends entirely on whether the incoming administration is prepared to endorse or at least step aside and permit emergencies reform to proceed. In sum, very briefly, it is intended to be much clearer about the limits and accountability to Congress of presidential authority to declare unending emergencies without any reporting requirement to Congress, without any accountability, essentially, for the exercise of that authority. Likewise, Insurrection Act reform doesn't mention Congress. The statute itself, as it currently exists, doesn't mention Congress at all and doesn't subject the president to any reporting requirements or any accountability there either. These seem to be issues that should be bipartisan in character, because just as there will be Republican presidents, there will always be Democratic presidents, and the Republicans will be suspicious of Democratic presidential overreach, and likewise, Democrats will be suspicious of Republican overreach. So there ought to be some bipartisan basis, but I think whether or not that can happen now is very much up in the air.
Judge or Don, do either of you want to say anything about that?
Well, I will just say that with respect to the use of the military, there's a lot of talk about that in relations to dealing with our immigration, our border crisis. I've always been opposed to the use of the military as a primary tool. I can understand having the military in a support role, but our military is trained to kill and to win. And to me, it's un-American to use our military against civilians, and in that situation. So we can talk about immigration all day. Of course, and of course, President Trump. He campaigned hard about deportation, mass deportation. I think he's going to find that it's a lot more difficult than he promised the American people, to round up millions and millions of individuals and deport them. But to use the military, I think as the primary tool, it would be a serious mistake.
Insurrection Act, and there's a bunch of other acts that I think Congress has passed over the years to try to acknowledge that the president has some authority, but to kind of frame it up in a way that's a little more analytical. And this is one of these things where, left without these statutes, the clash between Congress and the executive would probably be much more pronounced. And both sides, meaning Congress and the president, kind of do this sort of thing. Bob, when he spoke, it made me think of the War Powers Resolution, the idea of the reporting requirement. If you're going to declare an emergency and invoke the Insurrection Act or whatever, you need to let Congress know. It's an interesting thing. It's probably worth exploring. Not sure the executive would ever 100% agree with it if you're really junky in this stuff, and we all know this, but when you send the letter to Congress and War Powers Resolution, it never says pursuant to, it's always consistent with. So there's the executive not really admitting that Congress, that the resolution actually matters, but they're playing along. The border, that to me is legally the most challenging domestic issue, because it's not just domestic. because it's the border, and there is a perception that it's out of control. And again, big issue in the campaign. Elections have consequences, so it's front of mind of a lot of voters. But if you actually really try to sit down as a lawyer and figure it all out, it is hard. It is very hard. It's a mismatch of court decisions, a consent decree from 91. When was Flores? When was that case settled? That was the early 90s. That talks about how long you can hold children, and then, you know, the case law about due process attaching. Then you have sort of the use of force law. You have posse comitatus, you know, you kind of referenced it. And so it is something that when I was in, we spent a lot of time trying to figure this out. And it is not easy. It is not easy. And I'm not talking about immigration reform passed by Congress. It is a overlapping mess of Gordian knots within Gordian knots, a mixture of case law, statute, raw constitutional authority, and the like. So if I'm the incoming White House counsel, I'm probably finding the smartest people I can find and try to sit down and get really smart on that issue, because clearly it's front of mind of the incoming president. And when it comes to the presidency and the law, you actually really have to know the law, and it is a hard area of the law. IEPA is another one that you're going to hear a lot about, whether this and that is an emergency or not. Another area where I think that was passed in '77, relatively new. A lot of stuff was passed in the '70s that I think sounded like a good idea, but now you kind of, it seems like a lot of this stuff, it all goes back to then. And it's another area that is potentially full with unchartered and untested authority. What is something that can qualify as that sort of emergency? It's the environment. I thought we'd see the outgoing administration win the race to the bottom on sort of innovative use of sort of the idea of an emergency power. People are afraid that, you know, the once and future administration was going to get carried away. But at this point, trying to keep it at sort of a certain altitude, these are not easy legal issues.
Let me ask about one more area where the president has very broad legal authority, and that's the issuance of pardons. Would any of you like to comment on, obviously a whole series of standards and norms and processes have grown up. None of them are legally required. So how should we think about the pardon power and its possible use and abuse going forward?
Pardon power is in the Constitution. In a way, it predates the Constitution. It kind of goes back to the Crown. We have vestiges of what we fought against. And it makes, to me, it makes some logical sense if the executive, being the president, is in charge of the executive branch and sort of the law enforcement branch. He also has the authority to kind of forgive all sins. A lot of processes have popped up over the years. DOJ has its pardon process, pardon counsel, recommendations come over to the White House counsel, they go to the president. Sometimes the White House counsel can do recommendations. Sometimes people just kind of come in through the side door and ask for a pardon. And sometimes that's resulted in legal action. I'm thinking of tail end of the Clinton administration. There were some investigations over some pardons. And you know, it's one of these powers that I think is plenary. The president gets to do it. If he writes it on a Post-it note, I guess that's a pardon, but if you try to sort of present that in court to quash an indictment, a judge is probably not going to really think that's a real pardon. So there is this kind of balance, and I think that, you know, it's up to the president how he wants to do it. I tried to, you know, we always wrote memos, we always briefed it, and at least in my time, there were a lot of robust discussions about pardons. And you know, it wasn't necessarily the traditional through DOJ process all the time, but that process was still going. You know, one of these powers the president has, and it's life in the big city.
I had a pretty good idea of the kind of cases that President Bush would be interested in granting a pardon. So we had a pretty streamlined process. Most of them, like Don said, went through the normal pardon process through the Department of Justice, the pardon attorney. Then we go through the Deputy Attorney General, and then come over to the White House Counsel's Office recommendation of pardons. And the president would generally accept those. But there were a few, particularly at the end of the administration, that came in through through sort of the side door. The most interesting question in this area, as far as I'm concerned, because the Constitution, I mean, it doesn't limit the pardon power, is whether or not the president can pardon himself for federal crimes. From my perspective, I think you can make a strong argument. It's unlimited, so it doesn't limit the president. It doesn't stop the president from pardoning himself. That may seem wrong, but again, I could make the argument that the president does have the authority to do that. But I'm willing to hear contrary opinions from my colleagues up here.
You think he might have the authority to do it? I'm sorry. Yes. Yeah. So, in the maybe questionably named book that Jack Goldsmith and I wrote called After Trump, and by the way, there was nothing in the book that suggested when we would be after Trump. So I think we're okay. If you look at it that way.
It could be after Grover Cleveland.
Yes, exactly. But we talked about the pardon power, and there is a very thin executive branch law. It's a conclusion with very little analysis. I think it was issued in 1974, in which the Office of Legal Counsel suggested, indicated, it's hard to say ruled, that a self-pardon was not constitutional on the ground. And again, it's very thinly analyzed, and I don't think it constitutes particularly strong executive law precedent, executive branch precedent. In any event, the President of the United States isn't bound by it anyway. The President could say, well, that's very nice, or else he has that opinion. I could care less. I do think that Congress could, and I'm not saying it will, but Congress could lay down a marker in two areas, whether it ultimately could prevail, given what Don and the General have said about the apparent full textual commitment to the President of the pardon power. One is self-pardons. Congress could lay down a marker about that. But the second is the corrupt use of pardons. Now imagine, for example, that a president sells a pardon, just sells it. Something seems to be wrong with that. I think the Constitution protects the pardonee who accepts the pardon. I think the pardon is still valid, irregardless of the president's corrupt purpose. It is not clear to me that the president is free of potentially legal exposure, but that in turn raises the question of what are we going to do about questions about the degree to which the criminal laws subject the president to liabilities for various acts of an apparently official character that may be corrupt in nature, and that brings in the effect of the immunity decision and so forth. But it's an area that needs attention, and it's not going to get it anytime soon.
We have just a little time left. Let me ask Judge Gonzales, in light of your comments about how you felt the day after the election, your reverence for the office, let's say hypothetically, a lawyer friend of yours comes to you and says, I have an opportunity to go into the new administration. It's for a job I'd really like. I'm generally with the president on his policies, but I'm apprehensive about the kinds of issues that people have raised, rule of law, that kind of thing. So should I go in?
Absolutely.
Could you elaborate?
Well, I mean, if the person is a friend of mine, I'm hopeful that that person is someone of high integrity. And we need good people to serve. Quite honestly, we can't abandon our government. We need to have good, committed, strong people to serve in our government. That's how we best protect the rule of law, as far as I'm concerned.
Okay, so Bob and Don, they then come to you and say, I talked to Judge Gonzales, I'm going in. What are the pitfalls I should be aware of? How should I know when I've been there too long?
Come on now.
No,
Giving
it's a
me
fair
that
question. Haven't we all gotten this question?
Oh, 8 times today before lunch.
Right.
Sure. You want the answer for free? Oh.
Do you really charge the people who come to you and ask you the question?
No, but it's a deterrent to keep them away. Look, look, the downsides are there has become a cycle in Washington, sort of more pronounced sometimes in certain administrations than others, where scandal erupts and all of a sudden you're caught in something and you got a lawyer up and it can be very expensive. And you may leave in worse shape than you were when you came in. And merely because you think you're smarter or better educated or more savvy than the person who did it last time doesn't mean it's not going to happen to you. It just kind of, sometimes this happens. The other downside is the delusion of grandeur that a certain title is going to sort of be instantly monetized at the back end. If you're going in for that reason, you probably shouldn't go in, because although that does work for some people, the people that it works for probably had a career before and are going back to a career they had after. So if you think this is some magic ticket to either make money or get invited to dinners, you're probably doing the wrong thing. And it's amazing how many people, really younger generation, see it as a way to sort of, you know, be cool and that kind of thing. If you're going in for the reasons that Judge Gonzales says maybe you want to go in, then you're probably not going to have the afterwash or the downside that the folks who are going in for the wrong reasons would have. But it's not nearly as cool as some of us made it look. You know, it's not fun afterwards if you're kind of caught in the jet wash.
I've given it a lot of thought, and I'm not going to be going into the administration. I know, Don. I hear you, General, but I just don't feel I can. So, Don, if you urge me to do it, I'm going to have to turn you down. I would like to carve out
I don't
one.
actually. I don't make that ask anymore. It's not my job.
Fair enough. I will say one thing that I think is really important. I'm going to speak specifically to lawyers. That is to say, I think lawyers who go into law jobs in the government, they ought to, in the course of interviewing for particular positions, try to get a sense of the culture that they're buying into. There are questions that they should ask. I think it's important, I agree, for every government to have people available of high quality and integrity to serve. But I think lawyers in particular, and that's what, you know, I'm a lawyer, all of us are lawyers, and that is the vocation that we're concerned with here, need to be confident, whether it's the Department of Energy, Department of Justice, whatever it may be, that the culture is one that lawyers can feel comfortable with as a matter of professional ethics, as a matter of what they're going to be asked to do, as a matter of what they're going to be permitted as lawyers, how they're going to be permitted to operate. And so that's the one piece of advice I would give to any lawyer who would consider a job in the government.
That's a great point. If I can chime in, there's a whole bunch of jobs in the federal government filled by lawyers that aren't really practicing law. They may even have the title of counsel, but they're more policy lawyer types. And I think Bob's point is something I'm going to incorporate, you know, tomorrow when people ask the same question all day, is you have to really know what you're hired to do. Are you there because you're going to be kind of more of somebody to shape policy, or are you actually going to be practicing law? And is that legal analysis going to be something that's going to be accepted, relevant, or are you just going to be kind of writing? The other extreme is a bunch of law review articles that no one ever asked for. Maybe that'll be fun for you, but it doesn't really help. One thing I do try to tell people, and this is as good an audience as any, if people go into administration and they're trying to be a lawyer and they're trying to be what I call a real lawyer, I think as lawyers we need to try to back each other up. And if someone is not quite playing it straight, there's ways to kind of put a little pressure on that. But the idea of sort of attacking the lawyers instantly and that kind of thing, I think deters folks who may want to give it a go, and will deter precisely the kind of people you probably want to go into administration, to try to actually do some research, do some real work on what really are the presidential authorities, whether from the Constitution or a statute. And the more we sort of go hog wild on folks that kind of are trying to do the right thing, the tougher it is to get people down the road. And you know, it's wonderful to be here with you know, a former Attorney General and White House counsel, and Bob, who I've known forever, White House counsel, that you can see, I hope, that we may disagree on little things here and there, but there was a lot of agreement here, and we're all friends and we get along. And if this were more what Washington was like, we'd probably be taking the temperature down in a lot of ways. But you know, it's not really the world we live in. But when it comes to lawyers and the law, let's try to give the lawyers the benefit of the doubt.
Thank you all for a great discussion.